Hi everyone. Modern biotechnology and its numerous fabulous outcomes have necessitated crisp and clear intellectual property rights or IPR so that the maker's brainchild remains protected and can't be misused. IPRs are intangible in nature, unlike tangible properties such as land, goods, etc., and include patents, trade secrets, copyrights, and trademarks that we'll be discussing in this video. The rights to property prohibits others from making, copying, using, or selling the proprietary subject matter. The IPR of biotech products include recombinant plant varieties, transgenic animals, etc. Now, a patent means grant of a right from competent authorities to exclude others from making, using, or selling the owner's invention for a period of 20 years according to US law. Patentable subject matter should be useful in practical sense, should be novel, that is not known or used before, non-obvious or not a modification done of a pre-existing item by an expert, and the invention should be described in sufficient detail so that it can be used by a skilled person for a specific purpose fruitfully after purchasing the patent. A trade secret includes private proprietary information, know-how, or physical material that churns out a definite advantage to the owner. Coca-Cola formulation is a trade secret that is straight out of our daily life and hence would be easy to comprehend for everyone. Trade secrets in biotechnology areas may include material like cell lines, conditions yielding successful hybridization, corporate merchandising plans, or even precious customer lists. Unlike patents, trade secrets have unlimited duration validity. Now about copyright. Protein or DNA sequence data, computer databases and scientific images, textbooks and instruction manuals may be copyrighted. Though these can't be reproduced without the owner's permission, but they may be freely used for educational purposes. A trademark is a word or a symbol adopted and used by a manufacturer or a merchant to identify his or her goods and to make the world view it distinct from those manufactured or sold by others. Lab equipments and cloning vectors in biotechnology carry unique trademarks. A trademark is a brand actually. Now, let's see how intellectual property could be protected. Protection is brought about depending on the pace of technological developments, cost involved in maintaining secrecy, and the need to show the patent to the buyer or investor. Life forms couldn't be patented before 1980s. Sir Anand Mohan Chakraborty was the first to patent a living being, that is, the oil-eating recombinant superbug Pseudomonas putida in the United States. Soon after, an oncomouse having human cancer gene was also patented. Since that time, we have come really far in this area, and all researchers are now encouraged to patent their novel and precious intellectual properties. Filing patents have been made much easier and user-friendly towards this goal. The biotech items that have been fruitfully patented include factor VIII for blood coagulation of hemophilics, tissue plasminogen activator to dissolve fibrin clots within blood vessels of heart patients, hybridoma technology for monoclonal antibody production, biopesticides and bioinsecticides such as Bacillus thuringiensis as well as transgenic Bt crops, fungi as herbicides known as mycoherbicides, tryptophan producing maize, polyploid oyster produced by application of hydrostatic pressure on zygote, so on and so forth. All of these are non-naturally occurring and non-human multicellular living organisms. Besides, Artificial genes and chromosomes may easily be patented by their makers. If the host organism is also novel, the organism along with the protein may be patented. Stem cells, primers, probes, vaccines, antibodies, cell fusions, immunodiagnostics, blood products, DNA and protein sequences, etc. can be patented in general. However, there are certain items which are not allowed to be patented in the interest of humanity. And these include everything dealing with alleviation of human disease, for example, bypass heart surgery, organ transplants, heart valve implants, artificial limbs, dialysis, plastic surgery, artificial insemination, in vitro fertilization, embryo transfer, cancer treatment methods, neurosurgery, and anything related to diagnosis, prevention, or cure of diseases. These indeed ought to be everyone's right and accessible to them. Global organizations looking after IPR rules and regulations are World Intellectual Property Organization, Geneva, African Regional Intellectual Property Organization, and European Patent Convention that came into force in 1978 and has 38 member states. Guys, everyone must know about IPR these days, and we have tried to describe it in an easy to assimilate manner. If you like it, please share this video with others. Like it on YouTube by clicking the thumbs up. Subscribe and click the little bell icon so that you keep receiving more such lucid and useful information effortlessly. Our mission is to make studies easy for everyone. Thanks for watching and see you super soon.